Recording in progress.
Iniciamos.
Buenos días a todos los presentes en este acto. Es para la Academia de Ciencias Políticas y Sociales un deber para con el país el compromiso asumido en la realización de una serie de eventos acerca de la reclamación venezolana sobre la Guayana Esequiba. Hoy realizamos este quinto encuentro que lleva como tema el laudo arbitral del 3 de octubre de 1899 y el memorándum Mallet-Prevost. Es conveniente mencionar, tal como fue señalado por el académico doctor Isidro Morales Paul en 1999, lo cito textualmente, que no es la primera vez que las academias nacionales se ocupan del tema del famoso caso de la Guayana Esequiba. Ya en 1983, las academias de Ciencias Políticas y Sociales y de la Historia realizaron un ciclo de conferencias relativas a la reclamación venezolana sobre la Guayana Esequiba. En aquella oportunidad realizamos, dice el académico que citamos, realizamos una exposición crítica sobre el tema y tomamos la decisión de iniciar a título personal una investigación cuyos resultados nos sirven de base para la presente exposición. Esa investigación, añade el académico que venimos citando, enriquecida por novedosos elementos de juicio, reitera de la manera más rotunda la posición histórica de Venezuela al denunciar ante el mundo la farsa histórico-política que sirvió de justificación y respaldo al tristemente célebre laudo arbitral de París. En un libro publicado este año por la Universidad Católica Andrés Bello, el reputado historiador venezolano Manuel Alberto Donís Ríos señala: la iniquidad del laudo de 1899 no durmió el sueño de los justos. Se mantuvo en la prensa nacional y en las aulas de clase. Los gobiernos venezolanos decidieron velar por el mantenimiento estricto de la frontera con Guyana británica y al mismo tiempo no favorecer aún más las aspiraciones británicas que en diversas oportunidades intentaron modificar a su conveniencia la línea del laudo. La revisión del laudo de 1899 comenzó a exigirse en diversos escenarios internacionales a partir de la presidencia de Isaías Medina Angarita en 1944. El evento que hoy nos congrega tiene una especial importancia por las argumentaciones que el mismo puede generar para la defensa de los intereses del país. Ello constituye un elemento central que le da una significación capital a este acto que nos congrega hoy. Estamos recurriendo al pasado para traer toda una valiosa defensa del país producida a lo largo de los años por un sinfín de venezolanos, algunos de ellos valiosos académicos. Todo ello con el objeto de reparar los efectos judiciales por un laudo arbitral nulo e irrite. En este caso, es perfectamente aplicable lo señalado por Hannah Arendt. El pasado no lleva hacia atrás, sino que impulsa hacia adelante y es centro de lo que se podría esperar Es el futuro el que nos conduce hacia el pasado. Hoy el pasado se hace futuro con la valiosa intervención en este encuentro de un grupo de expositores notables, como son Rafael Badell Madrid, Carlos Ayala Corao y Milagros Betancourt. A ellos se suma la actividad moderadora del académico doctor Román Escobar León y la siempre valiosa colaboración y apoyo técnico de la Fundación Universitas. Especial mención debemos hacer al trabajo realizado por el académico Héctor Faúnde en el diseño y coordinación de estos encuentros. La academia se siente hoy más que nunca comprometida con un tema que ha ocupado una parte muy importante de su reflexión a lo largo de su más que centenaria historia. Compartirla hoy con ustedes es un honor que nos brindan los asistentes a este acto. Muchas gracias.
Thank you very much for the President of the Academy, Julio Rodríguez Berrizbeitia, for the presentation. As a moderator, I'm going to refer as how it's going to be the logistics of this event, of this new event, in continuation of the previous ones, very successful ones about this fundamental subject for Venezuela, as it is the conflict over the territorial conflict that we have with Guyana. Speakers are in first place Rafael Badell, second place Carlos Ayala, and in third place Milagros Betancourt. Regrettably, Emilio Figueredo, that was the fourth speaker, had to a last-minute flight and he cannot join us today. Each speaker has 20 minutes. When that concludes, we'll open a very important part, which is questions and answers for the time that is necessary. We calculate that around noon, we're gonna close this event. I'm going to disappear for a minute and then come back when 2 minutes are up for each speaker. Even there are subjects that can be joined together. Possibly what is going to happen is that they will complement each other from different point of views. The first speaker is Rafael Badell, Madrid, a scholar, a tireless scholar, main professor of Universidad Católica Andrés Bello. Is a current professor of and the chief of the class of procedural law. He's a catedrático of Andrés Bello University of Oxford, and also academic in that same university. Professor also of public international law for a long time. I'll give the floor to Professor Rafael Badell for 20 minutes. Please go ahead. Dr. Julio Rodríguez Berrizbeitia, President of the Academy of Political and Social Science, and other members of the Academy, and members of other corporations. Ladies and gentlemen, special guests, attendants to this event. As it was referred by our President, this is a very important topic for this Academy, both individually, both from the past and from today. In those bulletins, we have very valuable documents and pronouncements. This is a series of forums coordinated by Dr. Faúndes Ledesma is clear proof of this. We thank Dr. Faúndes for inviting us to participate. To Dr. Ramón Escobar León for this generous presentation, to the members on Universitas Foundation for the valuable technical support, and Mariana Escolaro for the simultaneous translation of this event. We must now refer to in this opportunity to the nullity of the Paris Arbitration Award of October 3, 1899. At 1 o'clock in the afternoon of that day, Tuesday, October 3, 1899, after 54 hearings held in the halls of the Palais d'Oxa in Paris, in execution of the provisions of the Treaty of Washington of February 2nd, 1897, this award was rendered adopted unanimously, which is 6 paragraphs of 844 words, awarded 159,500 square kilometers of the territory. More than 90% of the disputed territory was rendered in favor of Great Britain. None of the arbitrators who signed that award were Venezuelans, and neither the process were conducted only in English, the language of the other parties. The other party, Venezuela, was not allowed to appoint an arbitrator as Britain was, nor was its language taken into account. That Paris arbitration award is null and void for multiple violations of the Washington Treaty of 1897 and the international law in force at the time. First, it is necessary to emphasize that under the terms of the Treaty of Washington, and in particular, Articles 3 and 4, it was clearly that it was an arbitration act of law. As such, the arbitrators had to respect the letter and spirit of the Treaty of Washington, study, investigate, and ascertain the legal title of each of the parties, and apply it to the international law of the time. They also had to comply with the basic rule of acting impartially and carefully, and to motivate their reasons so as to inform the parties and the world of the factual and legal elements that were taken into account. However, none of this happened. On the contrary, the arbitrators decide with total discretion and without taking or not value none of the vital titles of Venezuela, nor the proofs that were in their favor, violating a due process. This is despite the fact that Article 3 of Washington Treaty states that the tribunal shall investigate and ascertain the extent of the territories respectively, or that it could be legally claimed by the parties. I end the quote. The expression lawfully claimed by the parties imply that in resolving the dispute, the arbitrators should only consider those that the parties could prove in good law. The arbitrators were required to analyze the titles of the parties and consider the law applicable at the time of the dispute, and the scope of that dispute was limited to the territories that could be legally claimed by the parties. The expression lawfully claimed by the parties implied for the arbitrators the duty to decide according to law, meaning according to the principles of international law in force at the time, and consequently to determine the legality of the claim. Obligation to investigate and ascertain implied that the arbitrators had to take into account the legal titles of each of the parties and corroborate that they were indeed susceptible of being considered as evidence of their claims. This obligation is also derived from the Article 5th of the treaty, according to which the arbitration shall proceed to examine and decide impartially and carefully the questions submitted to them. That, however, was not the case. The arbitrators decided with total discretion and without taking into account any of the valid titles and evidence that favor Venezuela. Among them, as an example, the letter dated March 4th, 1842, by Henry Light, governor of the British Guyana colony, addressed to Lord Stanley, who was Minister of Colonies, which was a fundamental proof in favor of Venezuela's pretensions. Since the governor accepted in that letter that Great Britain had no claim on the Amacuro River to the west of Barima. In addition, it made very serious considerations that compromised Great Britain. The existence of the letter was known, but its contents were not. At the time, the Venezuelan representatives asked the arbitration tribunal to require the British to disclose it. However, this was never achieved. The arbitration tribunal did not proceed to comply with the obligation to impartially and carefully examine and decide this matter. That this document was not taken into account by the tribunal became known after the English confidential files were opened, as well as several materials of great probative value that were left aside by the arbitrators. There were many other serious violations of which Venezuela has evidence. There is evidence that the expanded line of Herbert's map of 1842, in other words, it took as authentic and adulterated map that was discovered 3 years before the award was rendered. Venezuela has evidence that the British Foreign Office was not aware of this line until June 1886. The arbitration tribunal communally decided which evidence it will take into account and which it would not. The arbitrators decided with total discretion without taking into account Venezuela's valid titles and in violation of due process. But also the arbitration award of parties is null and void for having including excessive power and violated the Article 4 of Washington Treaty. The award is null and void for having including the fees of excessive power when it applied a statute of limitations in Great Britain, thus violating the Article 4 of the Arbitration Treaty, which established that adverse possession or prescription for the term of 50 years shall constitute good title. Venezuela had been led to believe through the minister, Jose Andrade, the U.S. Secretary of State, Richard, that the above-mentioned statute of limitations will only apply to effective occupation prior to 1814. If so, Britain will have no rights. But in truth, for the English, the statute of limitations will apply to occupations occurring 50 years before 1897. This erroneous interpretation, mistaken interpretation of the statute of limitations was taken into account by Judge Marwan. This interpretation of the statute of limitation was contrary to what Britain and Venezuela had agreed in the Treaty of November 1850, in which they undertook not to occupy the territory under discussion between the pseudo line of Schomburg, which was the highest aspiration of Great Britain, and the Essequibo. The agreement identified the territory in dispute at that time, in 1850, with the maximum claims of each of the parties, and with the commitment to preserve the status quo and not to extend the conflict beyond the territorial lines that were outside the area under discussion. So how could we reach to this mistaken interpretation of the statute of limitation? According to this interpretation, the principle of iudice possidetis facti was imposed over iudice possidetis iuris. Venezuela bases its sovereignty over the territory of the Essequibo on the principle of iudice possidetis iuris as a legitimate title to its eminent domain. Venezuela has always maintained that thesis that the eastern limit of its territory extends eastward to the Essequibo River, an area that includes most of the populated areas of Guyana. Venezuela has always considered this area as part of the former Guyana or previous Spanish colony of El Dorado, established in 1568, which in 1810 was part of the Captains General of Venezuela, created in 1777. In all Venezuelan constitutions from 1811 to Article 10 to the present, the national territory has been defined as that belonging to the Captain General of Venezuela prior to the political transformation of 1810. Venezuela's territorial sovereignty over the Essequibo is based on historical and geographical facts and documents, among them the royal decrees that confirm its historical rights since colonial times. None of this was addressed by the arbitration tribunal. But even accepting, which we do not, the statute of limitations interpreted in this incorrect way, it does not follow that the immense territorial awarded to Great Britain can be granted. In fact, it is demonstrated in the map included in the report of the Jesuits Herman Gonzalez that a territory that England could acquire through a rule of prescription, incorrectly, mistakenly interpreted, was much smaller than the one awarded by the award. The parties' arbitration award is also null and void for having incurred once again in the vice of excess of power, this time by deciding beyond the objective and subjective scope of the controversy, which was established in Articles 1 and 3 of the Washington Treaty, thus incurring in the vice of ultra petita. It is clear, according to Article 1 of Treaty of Washington, that the Arbitration Tribunal had the sole mission of determining the dividing line between the United States of Venezuela and the colony of British Guiana. Also, according to Article 3, which we have already cited several times as having been violated in various ways, the tribunal was to investigate and ascertain the extent of the territories respectively, or which could be legally claimed, and was to determine the boundary line between the United States of Venezuela and the colony of British Guiana. I close the quote. It is pertinent to ratify the very basic and elementary consideration that in international arbitration there are limits that arbitrators must observe. The first is a duty to abide by the subject matter of the controversy established in the treaty, which limits the jurisdiction of the tribunal. And second, and very easy to understand, is that the tribunal cannot rule on aspects that may involve other states that are not signatories to the agreement. The Paris Arbitration Award is null and void on the grounds of Ultra Petita. First, because it decided on the navigation regime in the Barima and Amacuro rivers, which had nothing to do with the subject matter of the controversy delimited in the treaty. And second, because the decision involved and affected states that did not sign the arbitration treaty, ruling on boundary issues that were even being discussed at the time, such as the border between British Guiana and Brazil. The Arbitration Award of Paris is null and void for lacking a statement of motivation in violation of Article 3 of Washington Treaty and the general principles of international law, which established as a prerequisite for the validity of the award that it be rendered in accordance with the law, which in turn entailed, including the decision, the necessary and sufficient statement of reasons, motivations to enable the parties to know the assessment that was made of the arbitrators with respect to each of the legal titles presented and the reason explanation of why they decided as they did. The duty to state reasons to motivate arise in first place from Article 3 of Washington Treaty, which established that the tribunal shall investigate and ascertain the extent of the territory respectively of which may be, I quote, legally claimed by the parties. If the court was required to address the legal basis of each party's title, then it was required to give an account of how it had done so. Moreover, by the time of the decision, it was already a principle of international law that in arbitration at law, awards had to state the reasons on which they were based. Although the president of the arbitration tribunal traced several times at the first Hague Convention, which was held at the same time as the arbitration tribunal was deliberated in, to impose the thesis that arbitration awards should not be reasoned. However, the representative of other countries considered the contrary. They thought that it was necessary, and that was the thesis that prevailed. Guyana representatives at the International Court of Justice at the moment try to justify the unmotivated nature of the award, which by stating that, I quote, in light of the publication of voluminous reports of the party submissions and the copious evidence presented to the arbitration tribunal, and in accordance with the practice of the time, the award itself was succinct. I close the quote. This, however, was not the case. It's not true. 3 events of utmost importance and of which the arbitrators were well aware, determined the applicable law by the time the arbitral tribunal functioned and the arbitral award was rendered. First, the rules of the 1871 Treaty of Washington, signed by the United States and Great Britain, according to which the Alabama case was settled in 1872. Secondly, the draft rules for international arbitral procedure prepared by the Institute of International Law in 1875. And finally, the first international conference of The Hague in 1899. From these 3 events as a whole, the international law of the time was deduced, and all of them imposed the obligation to give reason to motivate an award. The rules of that case, the Alabama case, became general principles in international arbitration, binding on the parties, but were nevertheless ignored by the Paris Arbitration Tribunal in 1899. Moreover, the fact that voluminous minutes have been published does not relieve judges of the obligation to give reasons for the decision in such an important matter, nor the obligation it had to take into account all the evidence in the file derived from the aforementioned Article 3. As Hector Faundes states, according to Article 4 of the treaty, I quote, there were 3 options for awarding all or part of the dispute territory to one of the parties in dispute. It was natural and obvious that it would be necessary to indicate on the basis of which these rules that decision had been reached and why. It is clear, and I close the quote, it is clear that there could not be any motivation since the decision had not legal justification, but rather a political one. The arbitration award is also null and void because it violated principles of international law, as the arbitrators failed to comply with their duty of neutrality and impartiality, since at least the president of the arbitration tribunal, the Russian, acted openly in a biased manner. There is ample evidence that Federico de Martins manipulated and coerced the other arbitrators to obtain an unanimous decision turning an war of law into a political settlement. Frederick de Martins exerted undue pressure on the rest of the arbitrators, a matter that was proven actually years later in 1949 with a memorandum of Severo Mallet-Prevost, the lawyer of Venezuela, published after his death on December 10th, 1948. In that memorandum, Mallet-Prevost acknowledges that he and President Benjamin Harrison were aware of the collusion that existed between the president of the arbitration tribunal, Frederick Martins, and arbitrators appointed by England. There are therefore sufficient grounds to declare the nullity of the Paris arbitral award of October 3, 1899. Venezuela has sufficient evidence to demonstrate the grounds for nullity. The International Court of Justice is now the only place and the only instance to do this. As the work of this court and the facts of March of 2021, it was signed 8th March of 2022 for the Cooperative Republic of Guyana submits its memorial, and until March 2023 for Venezuela to submit. We have done a lot of work ahead to reverse the serious dispossession suffered by Venezuela. We trust that the confidence and it's overcome for the interest of the country. Thank you very much. Thank you very much, Professor Rafael Badell, because the time he adjusted to the time in 18 minutes. Thank you very much. I'm going to say hi to a few scholars that are joining us today, some by Zoom, some by YouTube, and also to the other professors that are attending today from University Católica Andrés Bello, University Monte Ávila, University Metropolitan. For all of them, our regards. I'm now going to present my friend Carlos Ayala, who is a constitutional lawyer. Has a lot of experience in interpreting the constitutional law and human rights, and knows deeply the subject that he's going to present. He was president of the Andean Commission of Jurists, also the Inter-American Commission of Human Rights, special rapporteur for the indigenous people. I'm going to say hi to Carlos now, who is in Washington, our first speaker in Boston. I remember, Carlos, the importance of the 20 minutes. Please go ahead, Carlos. Thank you very much. Thank you very much for that generous presentation to my good friend and companion and professional companion to Ramon Escobar, and of course to the others, professors, and of course to Dr. Maria Escobar for her generosity and her participation in simultaneous translation. Well, I'm going to start my presentation with a brief reference to. We are talking about the memorandum of Severo Mallet-Prevost, and who was Severo Mallet-Prevost. It is very important for our presentation today. First place, Severo Mallet-Prevost was born in Mexico, in Zacatecas, Mexico, 8th of October, 1860, and died 10 December of 1948. There are some summaries of the biography of Father Ramon Gonzalez, who made reference as a lawyer and engineer. Is son of a military surgeon of a North American that has joined the army in the war against Mexico, and then decided to stay there in Mexico. And he was married to Mercosio, daughter of the governor of Zacatecas. But now, since he was a child, career of Philadelphia as engineer in 1981, go back to Mexico to exercise the profession of engineer, and then he established himself in Philadelphia. We are seeing his binational character and knowledgeable of the situations in United States and Latin America. He established residence at the end in New York, and established started work and in a firm that his name as well. It is important the relationship of Mallet-Prevost with this issue, and it's important because Mallet-Prevost was named in the first place to join the special commission that named the Universitas Commission to the mission to determine the truthful line, the borderline between Venezuela and Guyana. Here I make a parenthesis that after the rejection of the proposal of the United States of the mediation to resolve the dispute between Venezuela and the kingdom, he reacted very strongly before the Congress of the United States, December 17th of 95, invoking, and it's very important, the Monroe Doctrine, and at the same time proposing the Congress the creation of a commission to determine which were the limits between Venezuela and Guyana. So we're talking about a commission that was unanimously approved by the Congress of the United States, and that was designed by the executive power in January of the following year, 1886. So precisely, Mallet-Prevost was designed as secretary of that commission. So is a person that comes years before of the arbitration, linked to knowledge of the subject, secretary of the State Commission. Another important fact that another member, there was a Chief Justice of the Supreme Court of Justice, supported the arbitration of 1999. Hence, this way, Mallet-Prevost, afterwards, after this commission is designed, the lawyer between, as we will see, as the representative of Venezuela. It is interesting that Venezuela designed before that commission as a lawyer, Sir William Scrooge. Mallet-Prevost, it is then very important since the very beginning, because he was related with the cause, and precisely is a fundamental figure before, during, and after. As we know, before this commission of 1897, Great Britain reacted as in danger that the States determined this border, and that's why they agreed to the arbitration arbitration treaty. But this was said to be an arbitration of law and not an arbitration of equity. It's an arbitration that have specific rules for the determination of and the limitation of the border, rules about the statute of limitation, rules about the sources of law, the acts of the arbitrators before the arbitration tribunal has rules, specific rules about the consequences of the assignation of the territory to one of the parties when one were subject to the other ones, and other rules for an arbitration that you will see the arbitration of law. The ones that preside them are jurists, two judges of the United States, not less of the US Supreme Court, and Frederick de Martin, very famous lawyer and very important chief of the legal services of the Zares in Russia. Venezuela was represented by 4 jurists, a former president of the United States that had known the situation created by this conflict because of the delimitation of the British Guyana by Venezuela, which was Benjamin Harrison, which the one that presided the representation of Venezuela, the legal counsel of Venezuela in second place, and former War Secretary General Benjamin Ferenczi, and in third place, the lawyer Severo Mallet-Prevost. Venezuela did count with the representation of his agent, as it known as Rojitas, but also joined by Jose Andrade, who at that point was Minister of Foreign Affairs. So then it was an arbitration with rules of law and represented by lawyers, by jurists. And by the part of Great Britain, Severo Mallet-Prevost made the arguments in behalf of Venezuela, and he did it by 13 continuous days. And at the end, the debate was closed, but ex-President Benjamin Harrison, which is a very remembered speech, and then he sent the juridical questions to the judges by the representatives. And according to the Washington Treaty, the parties presented in March of the final allegations. Venezuela presented 3 volumes in July of 1988. I'm going to show you briefly, but it's important because all this is documented and it was published in Venezuela, which was very important. In 1891 was republished. All these books about the history in 4 big volumes that contain all of these allegations of law. There are publications of our Ministry of Foreign Affairs about the arbitration. So here we find the arguments that Venezuela made at that point, and those are legal arguments, arguments according to the rules of international law. There are maps, there are memorandums, there are cross memorandums, and this is very important because we were in front of an arbitration, and eventually in 1899, when came together in session to deliberate 45 sessions, that they were still to get motivated in law, 45 sessions of 4 hours each until September 27 of 1899 that were published, as you are seeing, both in the United States, also England and Venezuela. Now, with occasion of that debate is the famous interview that requested the Chief Justice of the United States, Severo Mallet-Prevost, and the region, and that had place in a hotel that was staying the judge, and they confirmed that he was subject of a blackmail by the judge of the Martin with other arbitrators, which take place over that arbitration to be fake. So they because the Matan counted with the 2 English judges and 2 in favor of England. In which Venezuela loses the openings of the Orinoco, which was the Martin proposed that they join this decision. To that, he responded to that memorandum, Mallet-Prevost, to President Harrison. But there, he said to President Harrison that he was certain that Great Britain was giving Russia something in exchange benefits. So how we deduce this? Well, from the visits that he made after the arbitration started to London, and also a change of attitude as described in the memorandum. And this is not mere speculation. This charade is not speculation. And it's not mere speculation because among other documentation, there is a book of De Martin, but Russia and England in Central Asia published also in Caracas with a translation and a preliminary study of a Uruguayan jurist, Hector Gross, in which precisely it is debated and it's studied the relationships, the influence relationships, geopolitical that was exercised England over Central Asia in a country, imagine yourself, which is Afghanistan, that it has just have an influence with over England. Russia is losing influence, and precisely years later, England and Russia subscribed an agreement after the arbitration in which they concede each other to the construction of and it was very important to the study that we're making. So it's not mere speculation that Mallet-Prevost was making. So finally, at the end, the arbitration award produced by unanimity, 1 o'clock, October the 3rd, 1899. One reference that we have to make, and it's happening right now in Venezuela. We are practically without government. Cipriano Castro has started the liberal restorative revolution at a few months before May that year. President Andrade was resigning. In those days, he has resigned October 19, and Castro finally entered Caracas in that last month. That it was the award was published, and he took charge of the president. So, worst case scenario possible. However, the representation of the country, there were, among others, our agents and lawyers. Very important that Venezuela never accepted this award because of the injustice and arbitrary. Because after all the legal arguments, proofs, evidence, discussion in law, it was dictated without motivation. It's interesting that the day after publishing the award, our people, Jose Maria Rojas, in an agent on behalf of Venezuela, presented a note. I quote, his surprise, inexplicable surprise for the decision of the arbitration tribunal, and he added, what we cannot know is the motive that Matan had to act and proceed this way. So this came to light, to public light for the facts, and also this memorandum that was the 8th of February of 1944. Sorry, 1944. To his partner, former judge, member of the firm, with the intention to be published post-mortem that occurred that same year, a few months later. in 1948. As a made in the American Journal of International Law the following year, in 1949, and in the next volume, of course, the debate starts and is published a refutation of Clifton and Child. So it's been questioned, this memorandum, because it's post-mortem, because it's the source of a lawyer by one of the party, but we all know that in law, the proof acquires validity not by itself, but also when it's also taken into account into the context with other proofs. Then the memorandum is being reinforced by other proofs that were previous, and then also considered to by the same fact that a memorandum is claiming that this arbitration is null. That is the source is the produce of a blackmail charade. Was present in all of the debates because he was interested because of legal reasons as a journalist, and in the magazine of Europe by then, and he was writing, and he affirmed that the English arbitrators from the very beginning were in favor of the Schomburg line, and de Martin proposed to the American arbitrators a compensation to Venezuela, a compensation that will allow them to go back from the Orinoco to the own, and Chamuan here affirmed that de Martin added that if the lawyers of Venezuela did not accept that, and I open a parenthesis, so affirming, he's affirming in 1899 the same thing that is affirming in 1944 in the memorandum Mallet-Prevost. So the fact is the very same by two different sources, and I quote, added, de Martin has signed that if the Venezuelan arbitration did not accept, he will count with the English arbitrators, which will secure England the possession of one of the shores of Orinoco. And it was profoundly disturbed by the American rich. They decided to accept an agreement that coerced by a necessity. They agreed to the arbitration award. Here is the alleged unanimity of the judges. So these facts are related, detailed by Carlos Alamo in his work of incorporation to the Academy in 1938. Another additional element, previous, of course, to Memorandum Mallet-Prevost, and with all the analysis that Carlos Ayala makes. But then after, but I have no time because of time constraints. We can see how other authors, Arthur Nausman, for example, also in publication, they agree with the validity of facts of the Memorandum Mallet-Prevost. So then we conclude by saying, by the facts narrated and described in this memorandum, there are certain facts about an illicit cause of the arbitration award of 1899. And those facts are demonstrated by other proofs that are coherent, that prove the same thing. And they were produced even before the memorandum, during memorandum, and after the memorandum. Thank you very much, and we will continue with the event. Thank you very much, Carlos Ayala. I also adapted with British precision to the time. Thank you very much for the substance and your thoughts. It's always calls attention that the arbitration award was signed in the middle of the crisis, a political crisis and military crisis, and that the great achievement of the Venezuelan diplomacy is that the Geneva Agreement was achieved during the democracy with Rómulo Betancourt, Raúl Leoni, our unforgettable Ministry of Foreign Affairs, Falcón Briceño. We must not forget him. We also have a democratic government that defends liberties, and it has leadership and strength, political strength. They were successful in the defense of the Venezuelan interests. Very good thoughts of Carlos Ayala. Now we give the floor a very esteemed person, Milagros Betancourt. She support me with her notes in class when we studied at the university, and I recognize her intelligence. She was gonna talk about the arbitration award in the light of the jurisprudence of International Court of Justice. Milagros is not only graduated from the University Católica Andrés Bello, but also he has developed highlighted a career in the Ministry of Foreign Affairs, a lawyer from the University Católica Andrés Bello, is professor of international, public international in that university, master's also. And he has written a very important work that is Introduction to the Study of Law of Treaties to 2004 and 2011 that was published by the Academy of Political and Social Science. He was executive director of SEDCA. Well, Milagros, you have 20 minutes. Please go ahead. Thank you very much, Ramon, for your kind words. That's right. I borrowed you my class notes and a great friendship. First of all, I want to thank the Academy of Political and Social Science for the invitation to participate in this event about the controversy between Venezuela and or the territory Esequibo, especially the coordinators, Dr. Héctor Faundes, and thank also the support of Mariana for the simultaneous translation. I say hi to my colleagues in these events, Carlos Ayala and Rafael. I'm going to center my presentation and briefly comment the award and the position of Venezuela in light of the jurisprudence of International Court of Justice. That now, at this time, we face a process before that court. It's very important to analyze those points because in this at this moment we're in a very similar position. The previous speakers have already commented in detail the content of the award and some other considerations related to what is set forth in the memorandum of Mallet-Prevost, published many years after the issuance of the award, which reveals the manner in which the arbitration was conducted and the pressures exerted by the president of the arbitral tribunal onto the other members to resolve the dispute. It is a simple, brief, unmotivated award and totally unfavorable to Venezuela. Its content is limited to transcribing the arbitration treaty by a way of an introduction and two operative paragraphs. The first, to establish the dividing line that determines the border between Venezuela and British Guiana, and the second, to declare the free navigation of the Amacuro and Barina rivers. In spite of the repeated expressions of disagreement and rejection by Venezuela from the moment that war was issued, we have to have present that the parties adopted measures for its execution, a consequence of the pressure exercise against Venezuela. There was established demarcations through various acts signed since the 1900s, the last one being the one of January 10th, 1905, a process that finished on November 3rd, 1932, with the signing of the agreement between Brazil, Venezuela, and the Kingdom to fix the traffic border point of Roraima. The idea of its reversion began to be formally aired and pushed forward after the lethargy of more than 4 decades in the speech delivered by Venezuelan ambassador in January 26, 1944, then the denunciations made before the United Nations annul the signature of the Geneva Agreement, all that we all know. This aspect of the passage of time in particular, I highlighted because I consider of special relevance in consideration by the International Court of Justice, as we will see now. There are various reasons that Venezuela puts forward that are very well explained by Dr. Rafael Badell, but to the purpose of this presentation, I'm going to highlight first the lack of motivation. There is a requisite of in public international law in the practice and in doctrine. The second is not and it was to include the aspect of free navigation. At the end, we will analyze these arguments in the light of the jurisprudence of International Court of Justice. First, of the King of Spain in relation to the controversy between Nicaragua and Honduras, decision of second about the arbitration award of 1899 about the delimitation of Senegal. In both cases, the court declared the nullity of the arbitration awards. We'll go to the first of Nicaragua. Was even 60 years after it was published. And Nicaragua was obliged. Nicaragua, on his part, solicited the court that did not have the character of binding arbitral award because of the manner in which the arbitrator was appointed, that it was also null and void on the grounds that first, the King of Spain had exceeded the limits of his competence by not observing the rules set forth in Article 2 of the Arbitration Treaty, and second, for lack or insufficiency of reasons in support of the arbitration's conclusion. Third, for having incurred the arbitration tribunal in an essential error. Finally, it's request that it was where it was valid, it will be declared inapplicable because it contained omissions, contradictions, and obscurities. By 14 votes to 1, the court decided that the award was valid and that the parties were bound by it. The first issue resolved by the court before entering into the merits was the time elapsed between the issuance of the award and nullity pleaded by filed by Nicaragua. In this regard, the court held that, in this opinion, and I quote, Nicaragua, by express declaration and by conduct, recognized the award as valid, and Nicaragua is not permitted to reverse the recognition and invoke the nullity of that award. Nicaragua's failure, many years after the award became known, to make any claim with respect to its validity, confirms the conclusion reached by the court. Likewise, the court, before entering into the merits of disputes, it pronounced itself on the nature in which it acted. And I quote, the court observes that an award is not subject to appeal and the court cannot consider the objections raised by Nicaragua on the validity of the award as if it were an appellate court. The court is not called upon to pronounce itself on whether the arbitral decision is right or wrong, These considerations are not relevant to the court's function in relation to these proceedings, which is to decide whether it has been proved that the award will be null and void and of no effect. The court dismissed each and every one of these nullity arguments presented by Nicaragua. I want to mention here because it's very important, the declaration, the statement and the individual opinions added to the court's decision by 3 of the judges of interest, the Judge Moreno Quintana, accompanied a declaration in the following terms, and I quote, as a true application by the arbitrator of the principle of utis possidetis juris, which for more than a century has governed the territorial situation of the states of Spanish America, will have attracted the attention of the court because of its importance, because it was the basis of Nicaragua's claim on the nullity of the award of the King of Spain, and because of the failure of the arbitrator to apply it. As to the form, the manner in which the court upheld the decision, the judge states, Moreno, he quotes, the case essentially concerns the invalidity of an international legal act, the arbitration award. The decision could therefore have been based on the intrinsic legality and on extrinsic legality of said act. The separate opinion of Judge Sir Percy Spender refers exclusively to the issue of preclusion for Nicaragua by the passage of time and the grounds for this alleged preclusion. In his opinion, this is no uniform custom in international law, which will permit the assertion that inaction on the part of states which may have an interest in invoking nullity implies a presumption of their waiver of the right to challenge the validity of an award. The most interesting, in my opinion, is the dissenting opinion of Judge Aroc Urrutia Holguín. It's very important for the decision of Venezuela and the award of 1899. Regarding preclusion or estoppel, he states in private law, in almost all legal systems, there are rules relating to prescription, with the exception of the rights of states which endure and cannot infringe by the passage of time. He continues saying, and I quote, in international relations, in certain cases, the challenging of an award by an interest state had been immediate. In other cases, many years have passed. In some cases, San Lorenzo River, the award of 1814, was protested at the note of 1831, and the response came in 1842. In the case of Venezuela and Colombia, the Queen of Spain award was issued in 1891. Venezuela originally accepted the award, but in 1917 entered into an agreement with Colombia to submit the question of the award's validity to the Swiss Federal Council for arbitration. About the application of utis possidetis juris principles, he states the countries of Latin America whose constitutions have established their borders on the basis of utis possidetis juris existing at the time they acquired their independence presuppose that strict legal decisions are adopted when they submit the limitation of their border to arbitration. This rule on which these parties have based their arbitration appeals is not merely academic. It is a sine qua non condition precedent that has its origins in the current constitutions of the states. Finally, in regarding the lack of motivation of the award, Judge Urrutia Holguín states that the majority of the court holds that an examination of the award shows that it contains ample reasoning and explanation in support of this conclusion. However, the large part of the awards is simply outlined one by one of the arguments that were presented by each of the parties concludes to judge the inadequacy of the reasoning in a series of arguments. Now, the Guinea-Bissau versus Senegal case involved the dispute of the existence of validity of the July 31st arbitral award. And Guinea-Bissau requests the court to decide first that the so-called award is in existence because one of the 2 judges who voted in favor subsequently expressed a different point of view. Second, in the alternative, that is null and void because the tribunal did not answer the second question posed in the arbitration agreement. And also, third, due to lack of motivation or totally insufficient, because the tribunal incurred in excess of power. The court decided as follows. decide unanimously rejects the conclusion of the Republic of Guinea-Bissau that the arbitral award is existent. By 11 votes to 4, rejected the conclusion of the Republic of Guinea-Bissau that the arbitral award is absolutely null and void and has no value. And third, by 12 votes to 3, decides that the arbitral award is valid and binding on the Republic of Senegal and the Republic of Guinea-Bissau, which have the obligation to give the effect to it. So these statements were added to these decisions, separate opinions by President Oran, Judge Lax, Need, and Shahabuddin, joined dissent opinion of Judge. Dissent opinion of Judge and Alamagri and Adocteri, because I'm going to refer briefly because it is important. The joint dissenting opinion, Justice Aguilar, Venezuelan, and centers especially in epistemological critique of the principle. The problem of the validity of an illegal award involves more than an assessment based exclusively on the axiomatic foundations of law. The authority of res judicata vested in any judicial decision is fully at work when the decision is underwritten by conviction. In regards of abuse of power, contrary to the opinion of the court, the authors of the joint dissenting opinion consider that the arbitral tribunal, by refusing to answer the second question, committed an abuse of power in petita or by omission, a hypothesis almost never found in international jurisprudence. I quote, the tribunal should have, they consider that the tribunal should have simultaneously taken into account the three constituent elements of the arbitration agreement, namely the letter, the objects, and the purpose, in order to interpret the arbitration agreement when it came to restructure the dispute. In regards to the powers of the court, in view of the dissenting judges, since the court, and I quote, was not acting as a court of appeal or cassation, it had a duty to be critical of any arbitration award before it. The task, including the mission of the principal organ of international treaty, is to ensure both respect for the rights of the parties and a certain quality of reasoning of other international courts and tribunals. The members of the international community are certainly entitled to benefit from the proper administration of international justice. The dissenting opinion of Judge Gramanti, in particular of the integrity of the arbitral tribunal, arbitration award, and the discrepancy with the arbitration agreement states, I quote, while it's important to preserve the integrity of arbitration awards, it is also important to ensure that the award complies with the terms of the arbitration award. Where there is a serious discrepancy between the award and the agreement, the principle of jurisdiction does not protect the award. Finally, in this case, dissenting opinion of just ad hoc theory with regard to the interpretation of the arbitration agreement states, and I quote, the tribunal should have interpreted Article 2 of the arbitration treaty in light of the object and purpose of the agreement in accordance with the rules of international law applicable to interpretation of treaties. As the comments before, we can reach to the following conclusions. First, the International Court of Justice will study and analyze the 1899 award in the claim filed by Guyana in accordance with the rules of international law and in the light of its own jurisprudence. Second, the tendency of the court has been to pronounce in favor of the validity of the awards. Third, the court has a very clear position that it cannot and should not act as a court of appeals and therefore should not pronounce on the content of the award and whether the award was well rendered or not. Fourth, regarding the grounds for nullity that have been alleged in these cases, it seems the court seems to have been very lax in the consideration of certain points, such as the lack of motivation, as well as the application of certain principles of law, and in particular, the UTIS principle. Fifth, the consideration of the passage of time and preclusion are aspects that should be very well reviewed with interest by Venezuela for the purpose of Venezuela's positions on the validity of the 1899 award. And I conclude by saying personally that it's indispensable that the Venezuelan state appear before the court to present and demonstrate the legal arguments, the legal grounds that will very well explain in this event, that also are contained in the publication that Carlos Ayala has referred in order to render the legal grounds for the reasons for the invalidity of the award before this court. Thank you very much. Thank you very much, Milagros, also for adjusting to her time, 18 minutes. Excellent. Very satisfied with the substance and the final conclusion. I find it extraordinary. So what other lawyers and professors have said in this issue, that Venezuela must appear before the International Court of Justice. As we have more time, because Emilio Figueroa could not join us, I have a few questions that I have here. I'll ask Universitas Foundation to recollect the questions posed in YouTube here in the chat, so I can read them and we can answer them. So by now, I start with the ones that I have now in the same order of the speakers. First, Rafael Madrid, Carlos Ayala, and at the end, Milagros Betancourt. And we can end as organized by noon. Questions for Rafael. Could you please clarify the importance of the importance at that time that the motivation had, because of the argument of Guayana that says that at that time it was not applicable, that rule. And also, you have a point that you couldn't address in your presentation. You can make use of until 5 minutes to explain better. Please go ahead. Thank you, Ramon. Well, the importance of motivation is fundamental. As I said in my presentation, I emphasize vehemently to the subject. We are before arbitration of law. At that time, the arbitrations were more of equity, ruled by people, renowned people. However, by the time that the arbitration award was rendered in October 3, 1889, it is already consolidated in public international law, a group of norms and rules that have become in the arbitration of law. And I said in my presentation, 3 elements that occurred in 1871, in which they signed the treaty, the Alabama case. Great Britain has violated the neutrality and impartiality, and the arbitration was motivated. And in that case of Alabama, some rules were adopted in the scenario of arbitration of law. In the draft of rules for international arbitration, it was established the obligation to motivate the arbitration awards. But an even more important element, and it's an intimate relationship with Judge Demartins and the president of the arbitration tribunal and the resolution of the Venezuelan case. This third element is a Hague conference that was organized, and it was held from the May 15 to July 31st of 1899, just when it was in session, the arbitration tribunal. That was the first formal instance in the where discussed arbitration rules. In that conference, they were discussed very important things that were concrete in the Convention for the Peaceful Settlements of International Conflicts. The importance of the conventions that were gather all the principles of on arbitration that were separated, but they're now ratified by the international community, but they were systematized, organized of the rules that the arbitration must comply. And that expressly say the obligation, the duty to motivate the arbitration decisions. Each of those votes must be motivated. And that was established as a validity requirement. All the judges were renowned, they had experience, and they know very well all that was happening in the international community. But not only they know, not only the arbitrators know, the ones that discussed the issue of Guyana, but Federico de Martin attended as a representative of Russia to the conference of The Hague at the time that it was developing. He even suspended the hearings of the Paris arbitration in 3 opportunities, once at the end of June and others in July, for the president of the arbitration tribunal could attend to the first conference of The Hague. When he attends the first conference of The Hague, he insists that it's not important for the arbitration, but the majority was imposed, that is the motivation is necessary, and is referenced in a particular article that is referenced by Falcón Briceño when talks about Federico de Martins, when he drafts the line of argument, when he's actually attending to the conference of The Hague. So it's very clear that the arbitration of law must have motivation, because if the arbitration award is dictated based on law, the arbitrators have a lot to say regarding what they took into account, which proofs they consider, which ones they did not consider, which is different when the arbitrations are by equity. So through the charade that the president of the arbitration could make, and the way he pressured the arbitrators from United States, and one of the fundamental elements that I can respond right now. In fact, it existed at the moment of the configuration of the will and the decision, and it serves to demonstrate that it was not taken into account, and to show the lack of respect to due process. Thank you very much. Thank you. Sorry, I have the microphone muted. I saying that thank you to Rafael Badell for having clarified this important requirement with so clear and precision. It's such a strong argument. Carlos Ayala now will have 5 minutes, and he has a lot of experience, because Carlos, I forgot to say in my presentation, he was a facilitator before the United Nations on behalf of Venezuela in the dispute of Guyana in the Geneva Agreement. And I want to remind as well that that he received the clever counsel of Carlos Ayala. I remember that Carlos was one of the advisors to that effect, and Carlos had plenty of experience. And taking advantage of that experience of the 5 minutes that you have, I will want to have this to make you this question. The other sources of proof that confirm what is said in the memorandum, Mallet-Prevost. Please go ahead. Thank you very much, Ramona. Thank you very much for your kind words. Well, it is important. It is important to take into account what it was said for Rafael Badell as well, to view the arbitration. It could have been agreed to be an arbitration by equity, by negotiation, to reach a decision by those commissions that have been created. But the Treaty of 1897 settles the rules for an arbitration of law. Remember, all the United States have established a year before a commission that had studied, and there is a report that it was made about the conclusions about that commission that had studied what were the limits of Venezuela. And you remember that there were dispute between iuris potestas iuris and iuris potestas facto, that it was alleged by Great Britain, but at the same time defending themselves in iuris potestas de facto. And Venezuela proved that despite the advances within the territory of Guyana by England, not only a series of protests and rejections and claims, as you know, at the middle of 19th century, one of the parts preached for a freeze of the status quo, and that precisely because of the rule to accept the possession that had more than 50 years. So in that way, we have factual studies, legal studies to resolve the controversy. So when you differentiate a legal argument and legal decision of a political decision in the arbitration, that nowadays is even easier, but at that point it was also clear because the arbitration did not comply the rules of the treaty. So the memorandum Mallet-Prevost, what it makes evidences of is that it was not decided according to law, but it was a charade. All of those arguments that it say that you could actually read and are contained in 4 volumes in 1982, and there's various libraries. There were made legal arguments for an arbitration of law, and the decision was not made by law, by a committed decision, and it was a charade as described as Mallet-Prevost. And it is said that if it was not decided by unanimity, the proposal of de Martin, it will still count with the English arbitrators to favor English. So that way, that's still a blackmail. So the importance of that proof, the evidence, is not uniquely based on the memorandum Mallet-Prevost, but all other proofs. So they're now in our arguments of nullity of the arbitration award in an illicit cause, the way it was produced, that arbitration, the fraud, in the way it was decided, the lack of motivation itself of the decision of the arbitration, but the one that allows us to put it on evidence that the decision that it was reached was not legal according to the Washington Treaty, but actually a charade, a fraud that violates the letter and spirit of the treaty. We see at the commission at this very day after, the representative of Venezuela directed questions and could not understand how the tribunal has reached that decision. We saw how in the Europe magazine, Chamoun made a narrative of how that decision was reached. And also he was saying that by hearsay of how Demartin had reached that decision and blackmail other arbitrators. But already in 1899, and in that magazine, they talk about the same facts, that how Demartin, without any motivation, maintained himself away of the rules and spirits of the Washington Treaty, was committed to commit fraud and to build this charade. And it also appears afterwards in the book of Demartin, one of the explanations. But in international law, there was a debate, as you know, in the Journal of International Law the following year, written by the child himself, where he rebates the legal validity of that memorandum. But in the following magazine, the following journal by William Holland Dennis, when he says in conclusion the following, and I'm sorry that I'm translating to English, there's no doubt of the truth and the substantive precision of the memorandum Mallet-Prevost, since the very moment that he narrates comes from his personal experience. Second, this memorandum of Mallet-Prevost gives definitive evidence of what we practically have studied about the story of the borders on Guyana. And nonetheless, that we are convinced is meaning that the decision was of a diplomatic commitment and not a truthful judicial decision. And that is why he says that it was reached the solution by unanimity. Also, there's another author affirms afterwards, he has a book of law of nations, that this arbitration was a political decision reached by Demartin. So affirm that it was a political agreement is violate the rules of the Washington Treaty. Also, Eduardo Jimenez de Arechica has also affirmed his conclusion that memorandum Mallet-Prevost, it is evidence that it was a political arrangement as a consequence of certain arrangements between Great Britain and Russia, meaning Great Britain conceded some benefits to Russia in exchange of a favorable attitude of Demartin for the English arbitrators. I close the quote. And this is in 1980. And with this, I conclude from that moment, it's proof and demonstrated that same fact is an additional element, but there are previous proofs during and after the memorandum that demonstrate that at the end, it was not an arbitration of law, but political agreement composed, built by Demartin through blackmail. Thank you very much. Thank you very much, Carlos. Consolidating and demonstrating. Thus, it was also said by Hector Founder since his last book, it was a fraud. It was fraud. Well, now it's the turn for Milagros Betancourt to answer this. Could the passage of time affect the Venezuelan claims before the International Court of Justice. Thank you. The following questions will be more brief. We can finish this period with the help of Universitas Fundación. Sorry, thank you. Thank you for the question. I think, no, that the passage of time could not affect the position of Venezuela, and that is why it's so important to read the dissident opinions of the separate opinions of the judges of the International Court of Justice, because those are the ones that help to build a position before an international law. As it was said, there is no rule in international law that precludes states to exercise their rights, in this case, to allege the nullity of the arbitration award. Precisely, one of the examples that they cite is the arbitration between Venezuela and Spain, that many years after, between Venezuela and Colombia. Venezuela and Colombia signed an agreement many years about the arbitration award. In second place, because Venezuela has maintained a constant, permanent, reiterated of reject and protest to the arbitration award. And in this sense, it is important to comment the definition of protest in international law. It's a formal notification of which one of many parties objects a position or a legal pretension before the international law. An unilateral manifestation of will in not to recognize as legitimate a pretension or to contest the legal validity of a pretension. So Venezuela has innumerable protests in relation to the arbitration award. And this will say that add up to the possibility that the passage of time could mean or affect its pretension, and also the demarcation that was made, because Guyana makes the argument that this demarcation cannot invalidate the position of Venezuela, because those works of demarcation were made under pressure of the United Kingdom. And we have to put it into context as well, what was the situation of Venezuela in those years before the great empires, the greatest force in the world at that point. So there are no sufficient elements to demonstrate the court that the passage of time could affect the legal arguments of Venezuela. Thank you very much. Thank you very much, Milagros. And now we start with the second series of questions. I will appreciate as succinct answers as possible because there are so many questions. Rafael, a question. Is there any proof of the blackmail? Well, as it says by Carlos Ayala, Milagros, Betancourt, there's plenty of proofs that demonstrate that was a fraud, that it was a political agreement for many reasons. So the memorandum Mallet-Prevost to see with surprise what happened in the meeting that had Judge Brewer, Fuller, and Mallet-Prevost. The Judge Brewer said it is useless to continue this fraud, pretending that we are judges and you are lawyers. The president and I have decided to reveal to you confidentially what just happened. Spartans have come to see us and inform us that Russia that the English arbitrators were supposed to decide in agreement with the Schomburg line, that Great Britain will give dominance to Russia to the openings of Orinoco. So if we take from origin they will approve the Schomburg line as the originary line. This is very grave. It shows firsthand how it can be, how the blackmail worked, the pressure over the English arbitrators for the American arbitrators to subscribe the arbitration agreement and achieve the Martin's arbitration award by unanimity. That's one fundamental proof that can answer to that question. Thank you. Well, thank you very much, Rafael, for his answer. There's several questions here. Let's do it by order. I'll go now with Carlos, and then Milagros if she wants also to answer some questions. This is from Ángel Serpa, professor from University. If we take into account the jurisprudence, if the jurisprudence of the International Court of Justice, question is whether the jurisprudence of the International Court of Justice leads on one either of the legal thesis. So as was said by Dr. Milagros Betancourt in the jurisprudence, there were decisions in which Venezuela can be supported about the nullity of the arbitration award of 1899 with the vices that have been denunciated as a violation of the treaty regarding lines that exceed the territory that were possessed, based of ultra petita to decide beyond what it was prescribed by the treaty, based of a lack of motivation. And independently on the lack of motivation, there is an illicit cause, illicit origin of the decision. With no doubt, all this depends, as it's been said, of the defense of Venezuela, the argumentation of Venezuela. It seems like a lie, but to go back to the legal knowledge of the argumentations of 1899 is our best arguments. All those volumes we find what was the state of the issue at that moment, all the studies that were made in Venezuela in the Congress of the United States. Those are the best defense of the rights that assisted us. And of course, it was always established that the west of Venezuela and Great Colombia and Essequibo River, the invasion, the part of the English, and it was accepted at a certain point by the Spanish crown of the Treaty of Munster in relation to the transfers of the territory. But this is necessary as it was it's been recommended by the Academy. Remember that the Cooperative Republic of Guyana is claiming that the International Court of Justice to declare the validity of the arbitration award. As a consequence, we have to defend the invalidity of the arbitration award, to declare its nullity, and it came to light that the arbitration award was we don't have to go back to the Geneva Agreement, which is a practical solution. And I think that the fact that Venezuela appears before the court is important not only for the court has elements, legal elements to consider, where before clearly a court of law that have the legal arguments. But also we don't have to discard, and the Academy has said it so as well, that also Venezuela go offensive, meaning that he do a countersuit under, of course, the agreement, and also the bad faith of Guyana in the negotiation of a solution, satisfactory solution for the practical solution of the controversy. It cannot be possible that under the Geneva Agreement, for more than practically a century, first the mixed commission and then the international procedures that were established, we could demonstrate, and I will say the first person, that there was no will of good faith from Guyana to negotiate a satisfactory solution for the practical solution of the controversy, because at the beginning they said in any of the circumstances, well, to reach that solution, you have to prove that the arbitration award is null. And when we demonstrated the causes of nullity, simply Guyana said, I'm not convinced. Until I'm not convinced, I will not go forward to the practical solution. So this is the opportunity of Venezuela to have in a legal forum the causes of nullity, the arguments that support our position and how we have talked today. It's not that it's only about the proof or the golden proof of memorandum Mallet-Prevost, but what is said there, it is the same that is said since day one of the arbitration award, and it was said during the years of the publication of the memorandum. And all the attitude of Venezuela, all the memorandums that are directed to United Nations, and the negotiations by the way of the Geneva Agreement, and the responses of England to our arguments about the legitimate cause that Venezuela has in relation to the public order crisis that arbitration award has. It is why the Geneva Agreement offers a satisfactory solution for the practical arrangement and solution of this, but taking into the International Court of Justice, now it corresponds to Venezuela, is putting to the table our best arguments that demonstrate a nullity of the arbitration award. So then Venezuela succeed in its position. So it's not just, well, the judges have to decide according to law, to go to the hearings, the best arguments. Well, thank you very much, Carlos. I have to remember that the Geneva Agreement was achieved in the governments of Rómulo Betancourt and Raúl Leoni, governments of the civil democracy period of Venezuela. I want to take the advantage of the opportunity to be insistent. There's 2 questions that I'm going to read. For one to be answered by Milagros, and also the second one by the collaboration of the 3 of you. We are reaching the ending of the event. One of Gabriel Ruan, very knowledgeable of this event, also a speaker in this series of conferences. Yes, I would like the opinion of the speakers about the evident lack of commitment of the agreement of 1850. It seems, Milagros, that it could be for you. I'm going to read the other one. Someone is called Luis Guillermo. I have the complete identification. Thank you for all. By the way, Dr. Rafael Badell is asking to share screen. Please, the foundation to collaborate with us. This question, I appreciate all the presentations of professors. Despite a solid legal position of Venezuela, I would like to know the perspective of the professors around some political weakness of Venezuela until now. Also, a lack of a strategy of but what was the role of the protocol of Port Spain in this issue? So the first question, Milagros, please could answer, and of course, if someone else wants to add anything else, and then the second questions for everyone. So Milagros, you have. Thank you, Ramon. If I understood correctly the question, why the Washington Treaty omitted to mention the status quo based on the agreement of 1850, which meant not to occupy the territory. For the truth, I don't have a particular response to that. I don't know if Carlos Ayala knows better, because we have to remember that there was a treaty subscribed between Venezuela and United Kingdom by the mediation of the United States. And I have not read in the literature or the official documents of the Ministry of Foreign Affairs that it was any comment on this particular. They decided just to center the controversy on the settlement of the borders according to the maps. But personally, I do not know. That's why I cannot have an answer on this. In relationship to the other question, I take the opportunity to answer. So I think that the position of Venezuela in different governments during the 40 years of democracy and the previous governments, Venezuela has been consistent in rejecting the arbitration award and considering it null in protesting that decision, in denouncing it before the international community. Therefore, I believe that precisely that consistency that in our position, and also furthermore, is the one that have led us to the success that was the Geneva Agreement, that the parties understood that there was a controversy, even though the existence of the arbitration award. Therefore, I believe that the position of Venezuela, independently of the protocol of Port Spain, that was it does not invalidate any position of Venezuela regarding this issue. Well, because politically they were not given the circumstances, but they are going forward. It was resume the work with the Geneva Agreement, and I think that Venezuela has sufficient arguments to demonstrate its consistency in a claiming of the original award of October 3, 1899. Thank you very much.
Yo creo que el doctor Escobar salió en línea. Yo invitaría, si no está el doctor Escobar en línea, que el doctor Badell haga su intervención y después yo haré la mía.
Missing in action. El doctor
Sí,
Escobar.
que no conseguimos ¿Me oyen?
Adelante,
¿Sí?
Rafael.
Sí.
Sí, no,
Please
yo
go
lo
ahead,
que,
Rafael.
para contestar, insistir en
No, to answer and insist on the question that Dr. Ruan, that he knows even more than us on this subject. It was not it was not taken into account for the treaty. It was mistakenly interpreted the clause of the statute of limitation. It was not used the agreement of 1850 and status quo. But the fact that the Washington Treaty did not take it into account, and it wasn't taken into account the arbitration award of 1899, it does not mean that there were not international conventions celebrated by two parties, by one part Venezuela and the other part United Kingdom, and the other to refrain to the invasions of England to the territory. So rapidly Venezuela reacted to this. This is why that letter was subscribed. I wanted to take 1 minute, and that's why I requested to share a screen to comment some reactions of the news regarding the arbitration award. This was October 11 in a magazine in journal in London, saying that I like the arbitration in the appropriate place. Immediately after the arbitration was produced, there is this chronicle that was published in London. That was what I wanted to say. There's several reactions of international press, United States, in England, in France, and in Venezuela. At the moment that the arbitration award was published, that it was not legal, based in legal reasoning, but felt that a little country was abused by a bigger one. Thank you, Dr. Badell. In absence of Dr. Escobar, I will take the floor very briefly. And then if Milagros would like to complement, of course, there is a question about the possible existence of a memorandum that confirms the same, but from the English side. It's very important, this question, because the fact is not only proved by the memorandum Mallet-Prevost, and the group of evidence from the moment that we're talking about after the publication of the memorandum, and with the deliberations that occur afterwards. In 1979, it came to light a letter of from an arbitrator directed to the Ministry of Foreign Affairs of the United Kingdom. Then the arbitrator, Lord Russell, to Salisbury, the October 7th of 1899, in which it seems more a letter of a lawyer of United Kingdom rather than an arbitrator. What it affirms, there is a maneuver of Demartin that apparently, according to this letter, it said the same to the English arbitrator. The English arbitrator shortly before were coerced by Demartin, saying him that if they do not subscribe, there will be enough votes for the American arbitrators. So this proves that again, that this was charade, fraud, manipulation that Demartin did to both sides to impose a political decision, and that he maneuvered both sides. He did not only coerce the arbitrators assigned by Venezuela, but to the other side as well. And this is an additional element, that this is a proof that it could go against us, but definitely to give account to this manipulation. Is published in the archives of the public office. And lastly, I would like to make a brief comment about the question of the protocol of Port Spain. By 1970, Venezuela was starting the conversations for the delimitations of any the Gulf of Venezuela. It was insisted Colombia to the delimitation of the areas, both marine and submarines of Venezuela, for what in that moment Venezuela was placing itself in a very delicate situation. To have their borders, both eastern and western borders, under pressure, and from that side is an element of the diplomatic exhaustion that Venezuela had through the recently born the non-aligned movement and the independence of Guyana before the Organization of American States had accused Venezuela. So it was a political decision to freeze the execution of the Geneva Agreement for 10 years to try to resolve the subject related to the Venezuelan Gulf that we already know what happened, and to go then into that discussion. I think it did not suffer in its rights because it was a mutual agreement. The rights were not compromised in occasion of this. And afterwards, a later process was reinitiated, more efficient, that led the Secretary General of the United Nations. So I do not believe that because of the protocol of Spain, we have not suffered a consequence demonstrating in the freeze of the execution of the Geneva Agreement for those years, and then to the act for United Nations. And of course, the desire manifested by Guyana is that freezing will be renovated for 10 more years. Was a great international and national debate. That was when I wanted to say to the question that was asked. Thank you very much. So I'm back here. Thank you for the collaboration from Julio Rodriguez, because I was connected by my phone. I have a power outage. I apologize. So these things happen for the ones who are in Venezuela. I don't know if Venezuela would like to make a reference. And I think then to give the floor to Julio Rodriguez, because we have reached the time. I don't know if you want to add anything else. Please go ahead, Milagros.
Que Milagros se congeló.
Se congeló Milagros.
Entonces, Rafael Badell, por favor.
Sí, como
sí,
no.
Todos
Bueno,
los que estamos en Venezuela tenemos estos problemas.
Sí.
Then
Bueno,
Rafael Badell, please go ahead. Yes, of course. Because it's my last presentation, I congratulate you for your moderation. You have joined it extraordinarily and take it to opportunity to insist in that Venezuela must fiercely defend with cleverness, respect to the adversary, must respect its position before the international instance that is the unique one through we can reach a solution. And I join the comment of Carlos Ayala, but we don't only have to be defensive, but and demonstrate the nullity of the arbitration award of October 3rd of 1899, but we also have the possibility to be of countersuit, and in that sense, I insist in the position of the Academy on this regard. Thank you very much. I will give the floor to President Julio Rodriguez. I will highlight that it's been consensus in the need of Venezuela to present itself and defend its rights before the International Court of Justice. It is very clear that arbitration award of 1899 is approved. To conclude, we have the additional minutes. Thank, of course, the speakers, the president of the Academy, its board of directors, and Hector Faundes for his initiative and capacity and ability to congregate audience despite the communication issues. To conclude, then, President of the Academy has the floor.
Yo quiero agradecer a los participantes de hoy. Realmente había unas altas expectativas con respecto en todos los sectores de la sociedad venezolana, incluyendo al gobierno, sobre las exposiciones que íbamos a tener en el día de hoy. Creo que han sido 3 exposiciones brillantes por parte del doctor Badell, del doctor Ayala y de la doctora Betancourt. Quiero felicitar por otra parte también a Ramón Escobar León, al académico Ramón Escobar León, por la moderación de este evento, y también a la coordinación ciertamente y a la realización general del evento por parte del académico doctor Faundes. Yo creo que la Academia ha cumplido hoy con uno de los compromisos que tiene el país, como señalaba al comienzo de esta sesión. Creo que, repito, es una sesión esperada, una sesión donde se han dado detalles que es importante y de acuerdo con las preguntas que se han realizado y con lo que los expositores han manifestado también, creo que no podemos esperar mucho tiempo para la publicación, por la vía que sea, de las conferencias que hoy hemos tenido, de la participación, de la importante participación académica que hoy hemos tenido, porque creo que el país está expectante frente a la defensa de sus intereses, y la Academia hoy, como lo ha hecho a lo largo de su más que centenaria historia, ha venido cumpliendo con el país, con ese compromiso, y haciéndolo de la manera transparente, haciéndolo de la manera completa, de la manera integral en que lo ha hecho a lo largo de toda la historia, no solamente las individualidades que la componen, sino la corporación como tal, que está constituida ciertamente por todos los académicos que de alguna manera han puesto algo de su esfuerzo a lo largo de la historia por tener un país mejor. A los que participaron hoy quiero agradecerles su presencia. Creo que estamos frente a un tema importante, y no solamente es importante haberlo oído, sino también el efecto divulgativo que eso debe tener dentro del país, porque creo que no hacemos nada sino hay una conciencia general en el país de que el territorio efectivo es parte nuestra, y de que esta es una pelea no de una generación como la nuestra, sino de todo el país. Estamos haciendo un esfuerzo para las futuras generaciones, estamos defendiendo un mejor país para las futuras generaciones que van a ocupar los lugares nuestros en este país, y creo que desde ese punto de vista la corporación está muy satisfecha por lo que hemos logrado en el día de hoy. Y sin más, quiero dar por concluido este acto y volver a agradecer a Universitas de manera muy particular, y a Mariana por la traducción que ha hecho también, cómo se ha ocupado de este proceso, cómo nos ha ayudado con este proceso y cómo ha estado pendiente del desarrollo del mismo. Entonces, nosotros en este evento.
Muchas gracias a todos. Adiós.
Muchas gracias a todos y a todas.
Salud, gracias.
Saludos.